We had no idea when we initiated this case that it would have such far-reaching implications. We simply assumed, perhaps rather naively, in retrospect, that this was such a flagrant case of piracy and would win. This was also the view of our attorney, who took on the case on the basis of no win, no fee. He was very well known as a specialist attorney in copyright law connected with photographs, and he was he had good grounds for thinking this. To go back to the beginning, we brought the case against the Corel Corporation, a Canadian software company distributing clip art discs within the US market, because they were evasive and uncooperative when asked to disclose the source of their images, nor would they allow us to view the transparencies that they had purchased and digitized. Out of the 700 works of art which the Corel discs factored and featured, 120 were in our catalogue and belonged to us, and a small but significant number could not come from any photographic source other than the museums which we represent. It was interesting that after the ruling, Corel removed the disputed products from the market. This seemed to us quite significant. We felt that it was essential to protect the income of the museums in question, and to ignore the piracy was to lose by default. Rather than single use or transient piracy, for example in the book that would eventually go out of print, this was a direct challenge to the museum's reproduction and licensing income, and to our ability to generate income for them. The image piracy was on a large scale in terms of number of images and their ready availability on both clip art discs and as files to download online. At a time when the demand for images to be supplied in digital format was increasing, the ability to control image access was highly dependent on legal protection and extremely important to the institutions involved. Apart from wishing to protect one of the few sources of income for a museum, as one museum director once said to me, we cannot deaccession our paintings, we can only sell the rights to our paintings. We also wanted to protect their standards of reproduction quality and accreditation. The loss of income would have gone hand in hand with the loss of control over credits, metadata, reproduction quality, and usage. Loss of credit is not only unprofessional and does a disservice to the image provider, but also has the potential to create an orphan work, which is very much a buzzword these days. In short, there was a sound principle at stake, which was supported throughout the museum, photographic and art communities. We received letters of support and offers of depositions from numerous sources, such as the American Association of Museums, the American Picture Agents, the Association of Picture Agents, PACA, CPIC, the European Coordination of Picture Libraries and Agencies, DAX, the Design Artists Copyright Society, the Museums and Galleries Copyright Working Group, the British Copyright Council, the Museum of Modern Art in New York, National Portrait Gallery and the Tate Gallery in London. The list was long and impressive, and the support within our industry was both heartwarming and reassuring. The verdict by Judge Kaplan was the decision of one low-level federal court in one US federal district. The decision goes against the accepted view that the photography of works of art requires creativity. In the case of Corel, the images were being sold for pretty much unrestricted use, and as such were encouraging a mushroom of unlicensed uses. And this was before the much more dangerous times in which we now live, with Google and Wikipedia integrated into everyone's lives, and their promotion of free use, if not fair use. As Judge Carpenter said in 1999 in his book on copyright, provided that the author can demonstrate that he expended some small degree of time, skill, and labour in producing a photograph, which may be demonstrated by the exercise of judgment as to such matters as the angle from which to take the photograph, the lighting, the correct film speed, what filter to use, etc., the photograph ought to be entitled to copyright protection, irrespective of its subject matter. In addition to providing needed revenue to museums and contributing to better quality reproductions, a strong copyright on reproduced works of art and transparencies actually encourages museums to distribute work more broadly, thus fulfilling museums' remit to encourage more public viewing and consumption of art. Without copyright in their museums, in their images, museums are likely to turn to contracts and licensing agreements as a way to control access to the works in their collections. Who can see them, who can photograph them, and what the photographs can be used for. These contracts have no input from viewers and consumers, and unlike copyright law, no fair use exceptions. From a policy perspective, a copyright in art reproductions fulfills the public interest better than the contracts that museums will turn to in order to protect their works if copyrights in art reproductions are deemed invalid. To go back to our case, as CPIC said, it was absolutely certain, in the opinion of a number of authorities, that the American judge had misunderstood UK law, perhaps through lack of precedence, and brave though his attempt was, he got it wrong. That, of course, was our view, and the issue that we're all debating today, so I now hand over to the experts.